both a friend and a partner in our work to work with fathers, father figures, and families throughout Erie County. Today's free legal clinic is provided through our collaborative partnerships between Say Yes Buffalo, Buffalo Public Schools, the Community Schools Initiative, the parent centers within the schools, and of course, Buffalo Prenatal Perinatal Network. The goal of the Volunteer Lawyers Project is to bring free legal services to the Buffalo community and to provide those services, wherever they're needed. So while some financial eligibility requirements will be in place, we encourage everyone, all are welcome to contact VLP by phone, and their phone number will appear shortly, for any civic legal matter, especially during this time period. So we hope everyone is safe during this time. We want to thank everyone for joining us. And I want to take a moment to introduce Paul Buchanan, our retired friend and judge. So before I do that, just want to encourage everyone who's joining us on Zoom today to please type in your name. Let us know what your name is in your chat box and where you're coming from, where in Western New York, your zip code, because we'd like to know where this is going, how far the reach is extending, and where we can hopefully provide services. And also, the first 5 people to log on to Zoom who are from the community will be eligible to receive one of these Fatherhood Nurturing Fathers travel mugs, or perhaps a t-shirt from our Nurturing Fathers program. So please go ahead and let us know where you're from. And then what I'm going to do now is just quickly introduce the Honorable Paul G. Buchanan. So Judge Buchanan was an Erie County Family Court judge. He presided over a variety of different cases to include custody, visitation, juvenile justice, child support, and of course, neglect and abuse. He created a nationally recognized juvenile justice part for juvenile delinquency, for persons in need of supervision, and for educational neglect, and a juvenile substance abuse treatment program. As a member of the Family Court Advisory and Rules Committee, he reviewed pending family court legislation and practices for the New York State Legislature. Through that committee, he was a co-convener of a New York State roundtable conference on the educational barriers to youth in foster care. That's super important for us here in Erie County. Not only that, Judge Buchanan is a board member for the Volunteer Lawyers Project of the Erie County Bar Association, which promotes and provides free legal services to those unable to afford them. He's a member of the Say Yes to Education Legal Task Force. Thank you very much for that, Judge. We do appreciate your service. And he's also a volunteer mediator for the Center for Resolution and Justice. Previously, he's even served as the president of the Buffalo School Board. So you can see he's got a range of experience from which he'll be able to speak to us today. But not only that, he's been an attorney for over 30 years, and he raised his children here in Buffalo. They went to Buffalo Public Schools from pre-K through high school. So he's not just a friend and a partner, but he's someone who's raised his children right here in our own community. We applaud him for that, and we thank him for that. It's certainly more of what we want to see here in Western New York. So again, thank you for joining us. And let me just remind everyone again, please let us know where you're coming from, what your name is, your zip code, and we will be in contact with you. Please use, later on, we will also hand out a few more articles, right? When we have a question that we'll share, but for now, I want to hand it over to our friend, Judge Buchanan.
Hello, can you hear me?
We can hear you, Judge.
Okay, well, thank you, everyone, and welcome. I want to thank all the people who put this together. It's very important. And I don't want to start listing people. Eric did a fine job of that. And I want to thank all of you who are watching today. Not only for watching today, but for your engagement and your interest in being a father or helping fathers, especially helping fathers with their children in education, because that, of course, is what is the bottom line here, is trying to help children with education. As you can see, this is through the Volunteer Lawyers Project that I'm appearing, and this is their number and their contact information. The presentation I am giving today will be available to you, the PowerPoint, and that can be, you get that from Eric or any of the other people through your organizations. And okay. Today's presentation is going to cover 3 points. Let me just go back one slide. So I want to provide legal and non-legal information, contact information for resources for yourselves, for information for your families and children. Secondly, to give a general overview of common legal matters handled by family court and legal matters for fathers and parents. And finally, how to access family court, especially in this time of COVID-19. As we do this today, it's Thursday, May 20th. Things are changing day by day. Erie County just opened this week to phase 1, and that was a surprise to everyone. The courts have been closed, the buildings have been closed under the stay-at-home orders. Those courts are slowly starting to open up within the confines of the stay-at-home orders and others, and I will cover a lot of that later. Just before this Zoom meeting, I was on a Zoom meeting with over 100 lawyers and judges talking specifically about opening up the courts and how that is going. So without any further ado here, I will give you these lists, contact information, if the slide will work. There we go. First of all, you get nothing else out of this presentation. This at the top is what you want. It's the New York Courts website, nycourts.gov. You can Google New York Courts and it will come up. This is what you want to go to. I'll be coming back to this throughout the presentation. And that's a great resource for all court-related matters, not just family court. Secondly, I'm dealing mostly with Erie County Family Court because that's where we're located. However, what I'm going to discuss is really relevant to any county in New York State. Will have these same procedures. Everything is the same. Here in Erie County, the Family Court building is located 1 Niagara Plaza, and that's next to the Rath building. And under normal circumstances, you can just walk in there and file a petition. Of course, we don't have normal circumstances right now, and that's a little more difficult. And during normal circumstances, Volunteer Lawyers Project also has a help desk there over from 11:30 to 2 o'clock most days. And they will help you with filing a petition or particulars like that. The following couple of slides I will go through very quickly. These are the legal services that are available to you. Volunteer Lawyers Project, Center for Elder Law and Justice, the Legal Aid of Buffalo, handles housing, tenant, mortgage, unemployment insurance. The Family Justice Center is a very important one. They handle domestic violence, and so they get a lot of views. This is an important slide, contact information if you're dealing with domestic violence. I think they also have a relationship with Haven House. The Western New York Legal Clinic also provides information. Neighborhood Legal Services is also another one. Again, this is a loose network, if you will. And if you call any one of these and they're not the ones who will handle your case, they're not going to just say, oh, gee, we don't handle that. They will help you find which other of these organizations you need to deal with, and will hand you off. There are also non-legal resources for you. Very first is Child and Family Services. They provide community support such as counseling and other supports. Other important numbers to have are the Domestic Violence Hotline, the 24-hour Addiction Hotline, and the Child Abuse Hotline. I'm also adding the Buffalo and Erie County Public Library. This is an, especially when we're talking about education, this is an overlooked, huge community resource. If you need to think about where can I bring my child, take them to the library. It's free. They're on bus routes. They have free parking except for downtown. If they're heated in the winter and air conditioned in the summer. They have activities. They have community information on the billboards. And what I would say when I was on the bench with cases, I would ask kids, what do you like to do? And they would tell me, they like to play music. They like to play basketball. They like hip hop, whatever. Ask your child that. Go to the library and, ask the librarian to help you find information, books, tapes, or CDs, whatever, online things that will engage your child. If your child does not have a library card, get a library card. They're free. If you don't have a library card, get a library card. It's free. Make a big deal out of it. Read to your child. Let them see you reading. That is about the most important takeaway that you can have with your child in trying to enhance their education is to read. More non-legal resources, rather, the Erie County Department of Social Services. Now, this is not the Child Protective Services in foster care. This is the Family Support Team. They're a multidisciplinary team with mental health services, substance abuse services. They help with runaways, things like that. They will meet with you and they will come up with an individualized plan for your family. Whatever your family needs, they will help provide it. You don't have to go to court to settle everything. You can mediate, and mediation services here are provided free by the Center for Resolution and Justice. This is their contact information. And they also have mediation services in many of the courthouses. Mediation is a non-court attempt to resolve issues between parents concerning children. And what's important about mediation is that the parents make the decision, not some arbitrary third party like a judge. Okay, so now those are the general overview of the resources. Next, the general overview of the law. Family court deals with children who are under 18 years of old for support, custody, visitation, paternity, neglect and abuse, and also domestic violence among parents, family members, and former family members. So how does it work? The paperwork is called a petition, and the petition is filed in Erie County Family Court or whatever family court. Right now, under COVID-19, we're dealing with virtual courtrooms, much like we're doing this now virtually, rather than as we were going to do it physically March 28th at Harvey Austin Academy. And I'll get more into that later. The person who files the petition is the petitioner, and the person who's filed against is the respondent. These are the terms used in the court. If you file a petition, or you're the petitioner, and let's say the mother is who you filed it against, she's the respondent. When you get to court, the judge will appoint an attorney for the child. So your child will have an attorney that's paid for by the state of New York, so you don't have to pay for the child's attorney. And the attorney will represent the wishes of the child, not what you want, not what mom wants. It's the child. On your first appearance in court, the judge will refer you to the assigned counsel program to see if you qualify for a free lawyer. And if you don't, you can appear without a lawyer. That's called pro se. If you qualify for a lawyer, then they will provide one to you. I always recommend people, take the lawyer if it's free. You can always change your mind later. Now, petitions can be filed for a number of things. Usually the first time it's filed is if there's no prior order from a court. So that's a determination for custody, visitation, paternity, or child support, just for the first time you're ever doing it. If you already have an order and that's not being followed by the other party, either not paying child support or they're not adhering to the visitation schedule or whatever, then you can file a petition to enforce that order. And all that does is bring you into court to say, Paul's not doing what he's supposed to be doing. We want him to do what the original order says. And then finally, and this doesn't look very clear on the slide, I apologize for that, a modification, which is a change to an existing order. So if your circumstances have changed and the original order doesn't really apply anymore, then you can ask for a modification. Let's say you worked a second shift and your visitation schedule is set around that, and now you work first shift or you have a different job or whatever. Or the original order was when your child was an infant. Your child's now 9 years old and that schedule doesn't work. Whatever the change in circumstances are, you can then ask for a modification.
Judge?
Yeah.
We've got a question related to the custody orders at this point. We have a father who's letting us know that he's not had court, he's not had visitation for over 60 days. So it's not being enforced. What should he do?
Well, he should file a petition to enforce the visitation order. And he would need a copy of that order to attach to the petition. And you can get the petition, and I will cover more of that detail as I go through this presentation. But you go to that newyorkcourts.gov website, and at the end of all of this, I go through how you actually find the form you want. Find that form, fill it out, and send it in to the courthouse, either by mailing it or and you can ask for makeup time. If you haven't had visitation for 60 days, what do you want? You may not get what you want, but you may, say, well, I missed, 4 weekends. I want an additional 4 weekends, or, a week in the summer, something like that.
That's amazing. Thank you.
Dealing with custody, New York State, there's no presumption of custody for either parent. Both mothers and fathers have equal right to the custody of their children. The laws that govern custody, there are two of them. One is the Domestic Relations Law, that's if you're getting divorced, and then Family Court Act, if you're not married, either already divorced and never got married. Both laws are identical word for word. It's just what context they're in. And what's funny, and I talk about this, neither of those statutes defines custody. It just says custody. And custody has come to, really be what we in the culture in society use as common usage behavior. And terms like joint and sole and residential parent come through court decisions, and they generally, revolve around how much responsibility and the decision-making authority that a parent will have for a child. Whenever a court is determining custody or visitation, as in that former question, domestic violence must always be addressed by the court. There has to be a search of the record to see, was there a domestic violence ever? And if there was, what's the court think about it in making their decision at that point? Again, yes.
If I can interject, I just wanted to let you know, I thought I was getting some feedback because of my laptop, so I unplugged my cord because my laptop is fully charged. I don't know if you might need to do the same. We can hear you. There's just a slight crackle in the background, so I just want folks to be able to hear you perfectly. Do you have are you charging?
No, I'm full. I unplugged it just before this because I'm fully charged.
You know what? You sound perfect right now. Maybe it was my laptop. I apologize.
No problem.
Before we go on, let me just say we've got our winners. We've got Justin, Terry, Daytwan, and Rodney. You guys will all have a pick of one of these varied mugs that we've got for the Nurturing Fathers program. So thank you for joining us. In a little while, we'll take questions from Facebook as well. Judge Buchanan? Okay,
and then very quickly, some of these are the terms that you will hear. Residential parent, that is the parent that the child primarily lives with, and that address is used for school registration purposes. Shared custody is when the parents, there is no residential parent, but the child lives essentially half time with each. Joint custody is when both parents are able to cooperatively make decisions for the child concerning the child's health, education, and general welfare. And this is the preferred method in New York State. So if you go into a court in New York and on a first time custody petition, there's no prior order, this is kind of what everyone expects to be the outcome, and you have to argue why there should not be joint custody. Joint custody doesn't mean that the child is going to live equally with both of you. It just means you both have equal responsibilities in raising your child. Sole custody, on the other hand, is when one parent has all the decision-making rights and responsibilities. However, the parent is not the sole custodian, still may enjoy and should enjoy a relationship with the child. In all cases, both parents should have, and if you're going through a proceeding or going to be filing, make sure this is in there, that both parents have access to all health, education, and welfare records and providers. Have the ability to attend your child's activities, whether it's school activities, teacher conferences, doctor's appointments, so that you don't have to get the other parent's permission to go talk to the teacher or to find out information from the doctor on your child's medical condition, things like that.
So I've got a question here. Now that we're talking about sole custody.
Yes.
For a father who, let's just say for the sake of argument, is doing everything he can to establish that the other parent really is just not, and I understand that there's an attorney for the child, but when there is clear, let's just say evidence, right? Not just behavior, but use of drugs, a host of other things. Let's just say that for some reason, we do know that there is evidence that the other family, the other parent, in this case, could be deemed unfit, quote unquote, right? Just typically, is there a a point in time by which a decision for sole custody should be rendered? I mean, because sometimes we hear of folks where it takes less than a year, and sometimes we hear of folks where it takes greater than a year.
Yeah, well, again, let me just go back and would say in that case, first of all, is there a prior order? Okay, that's the first question you will always be asked. Is it so if someone has sole custody or whatever, is there already an existing order, or are you filing a first petition for custody? And the length of time varies case by case. And no, I'm not going to be giving a great answer, but everything is really case specific and child specific. If you and the other parent come in and you sort of get along and you kind of, you have a couple of rough edges, but you kind of, muddle through life and take care of your kids, and, you just need a custody order. And, that may take, a couple of months, again, when you go into court, your first day, you file a petition under normal circumstances. COVID is changing that. And I'll get to that in a moment, the timeline. But, you would file a petition, you get an appearance in court within 2 weeks. You go in, the attorney for the child is appointed. Then you get a referral and the other parent gets a referral for an attorney. And then you're told to come back in a month. And then if you have it all worked out or don't, but close, maybe you come back in a couple of weeks. There you see that can be done in 8 weeks. That's pretty fast. Courts are not designed to be fast. Courts are designed to get all the information and give everyone their fair say. Everyone gets their day in court. But if it's a very contentious matter, and let's say that other parent has mental health problems or substance abuse problems and is not cooperative, or is been given time to get themselves clean and say, okay, well, here's a temporary order. Let's see how it works out and come back in 3 months. And then they fire their lawyer and get a new lawyer and want to fight, which is their right. That can, you can have a case go for years. And it all depends on how contentious one or both of the parties are. Some people use their children to get at the other parent, which is terrible. But it happens all the time. I'm withholding the child from you, not because you're bad, it's because I don't like you. And that hurts the child. If you have a trial, then the judge has 60 days after the trial to give a written decision. So there is some timetable there. Generally, the court wants to finish a case before a year, not to say that all cases take that long.
Gotcha. Thank you for that. So another question related to when you address COVID, I just want to throw this out there, and I'm sure it's probably part of the timeline, but because of COVID, were custody orders ever allowed to be stopped based on the family's choosing, based on the custodial parents choosing?
No, in fact, a decision just came out this week that I read yesterday, as a matter of fact, from downstate, New York City. Mother lived in New York, father lived across the river in New Jersey. They still have an ongoing case, and there's a temporary order of visitation, no determination yet of custody. And the father was supposed to have every other weekend or whatever it was. Mom stopped visitation saying, using the COVID scare, I'm afraid my child's going to get the virus going with dad. He had to go to court to enforce the order. There was an existing order, a temporary order, but it was still an order. The court made a decision and said a generalized fear of, catching the disease is not good. You've got to have a specific reason. and just saying that I think going to dad's is bad and would put the kids in jeopardy isn't good enough. And dad, said, I'll drive, I'll pick up the kids. I have a backyard, we social distance. And the judge ordered, you must immediately go back to, given the time, go back to the order, and gave dad makeup time. And that was decided just this week.
Excellent.
So, and what courts do not like, especially if you're in the courtroom, is self-help. And if there is an existing court order, you must follow the court order. And if the court order doesn't work anymore, that's why you go in for a modification. Things have changed. Now, a lot of times what happens, people have an order that's years old and they have, sort of adopted a new way of getting along and go along okay and do things loosely for a couple of years. And then the problem, comes up. And they come to court, and the court looks at it, says, well, we have an order from 3 years ago. And they say, yeah, but we don't follow that. And the court says, well, you have to, if you're asking the court to do something, they can only tell you to follow the order until you bring a proceeding to change the order. Now, another thing that parents get is visitation. Again, this may be as part and parcel of a custody order. There's a visitation schedule. And maybe you don't even have a custody order. You just want to visit with your kid, and you don't need a custody order per se. Anyway, you file for that. Again, the a big thing I skipped over, I probably missed a slide. When the judge in the court makes a decision on children, on any topic, it's always in the best interest of the child. That's the standard. And that's pretty, it's a pretty flexible standard. There's no real hard and fast definition. I may have skipped over that. Pardon me. Yeah, it was covered up by that logo. It's the best interest of the child is very child specific, and it deals with that specific time, those specific circumstances, and that child and those parents. It doesn't say, well, here's what Johnny Jones got for custody, with his parents. No, that doesn't matter. It's what's happening with Paul and his parents right now in May of 2020. Very quickly, visitation is just having access with your child. You can have schedule or not. The question earlier was, I'm not getting visitation, file a petition. If you're going to do that, also put in what you want. If there's a specific schedule that you want. I want every other weekend. I want every other weekend and 1 day a week. I want to split holidays or every other holiday. I want to split school break. I want 1 or 2 or 3 or 4 weeks in the summer. Try to be as specific as you can be, rather than just putting a general, I want visitation. That doesn't give the court anything to really zoom in on. Other terms that you may hear are supervised visitation. That's when a non-residential parent will have an initial period of supervised visitation. That's probably when there is a risk perceived to be perceived risk to the child. The parents can agree on a supervisor. Sometimes it'll be a family member, a grandparent, an aunt, an uncle, or someone appointed by the court. Sometimes there's agency supervised visitation, like the Catholic Charities, where the rupture or the risk is too great, and the parent cannot initially be left alone with the child. There's also therapeutic supervised visitation, which is the most stringent, And that's when there's a therapist in the room. And let's say those are for cases where maybe a father pops back into their life 6 years later. They haven't seen the child in 6 years. They can't just walk in the door and say, hey, come on, I'm taking you for the weekend. Or if there was prior history of domestic violence or things like that. So there'll be therapeutic supervised visitation. You'll also, in high contest situations, have neutral exchange locations. Not recommended. It's, causes it's traumatic for the child, but less traumatic than the parents fighting every time the child is picked up or dropped off for visitation, and therefore they may be done at community centers or libraries or police stations. Child support is another area. Parents have the responsibility to support their children until the child is 21 years old or sooner emancipated. Emancipation is being self-supporting. Not having a job at McDonald's, that's not self-supporting. But self-supporting is living on your own, either being in the military, being married, having a full-time job and supporting yourself. And until you're 21, if you're emancipated, you can become unemancipated, like if you lose that job. Family court deals with children up to 18 years old. Once you turn 18, family court no longer has jurisdiction. You can, if there is an order for support, that order can be reviewed every 3 years, or anytime there's an increase or decrease in income of 15%, or if there's a change in circumstances that the court should take a look at, like if there's someone gets a disability or has a medical condition. Support is
Judge Buchanan.
Yes.
Before we proceed, someone zoomed in a question regarding reasonable visitation.
Yes.
What's considered reasonable visitation? Is that per week or is that some other time frame?
Well, again, I'm going to give you the standard answer, which is it all depends on that specific family, that specific child, and those parents.
So
what's
what if-
reasonable to one is reasonable to another. Having said that, what is generally done is the parents get every other weekend, they split every other weekend, Friday after school to, again, this is very important. If you're going to take your child overnight, they have to be safe and they have to do their homework. The courts are very big on kids doing their homework. So if you are taking your child Friday after work or after school and pledge to get them to school Monday morning on time, if there's any homework to be done over the weekend, they're supposed to get their homework done. Or if you have them overnight from Wednesday to Thursday night, they have to get their homework done. So what would be considered a normal, not normal, but common visitation schedule would be every other weekend. Let's say you're the non-residential parent. Every other weekend, either Friday after school to Monday to school, or all day Saturday to Sunday, or something that fits their lifestyle. Someday during the week, either Wednesday after school till 7 o'clock, 8 o'clock at night, or get them to school the next day. If they have activities, you get them to their activities that are scheduled. If they're in, glee club or sports or boys or girls clubs, scouts, soccer, whatever, you don't say, well, I'm not taking them to soccer because it's my time. No, you take the kids. You rotate holidays, the major holidays, Christmas Eve, New Year's, Easter perhaps, Memorial Day, 4th of July, Labor Day. You may rotate those holidays. I'll take 4th of July on even years. You take 4th of July on odd years. split the school breaks. Either I take one break, you take the next, or, I'll take the first half, you take the second half over summer. You get, each gets 2 weeks of block time with the child, either consecutively or not consecutively. That would be a a common visitation schedule.
Understood. What about if we have children that are from infant to, say toddlers, basically preschool age children, but definitely an infant was the specific question that one of the fathers posted.
Well, fathers can take care of infants.
I would think so.
I mean, I would always say to the mother in my courtroom where she said he doesn't know how to change a diaper, I said, well, show him, teach him. He's got to know how to change a diaper. He's got to know how to pack the bag to take the kid to the park. No big surprise. You're going to need diapers and wipes and snacks and a bottle of milk or whatever. If the father wants the enjoyment of visitation, they have to show the responsibility that they can do it. And my point was always pull up or shut up. I mean, if I'm giving you a chance to fail. So you can take your baby, but if you fail, it's on you, and don't risk your baby. But of course, now if the baby's nursing, that's another thing. How much time is going to be away? So it depends on, again, case specific. How old is the baby? How bonded is the baby with the father? The younger the baby is, as we all know, that's when that bonding happens in that first 6 months, that first year. Fathers need to be around the baby in that time period to bond with the child.
Absolutely.
And even if it's only a couple of hours a day, it doesn't have to be a whole weekend. It's frequency. So anyway, that. I hope that's the question.
I think so. Thank you.
So getting back to child support is very formula driven. It came from a change in the federal welfare laws or social service laws many years ago. And for states to get their TANF money from the feds, they had to have a specific method of allocating child support. And that's why it's so formula driven. And at the moment, there we are. I'm having trouble bouncing these back and forth, sorry. But maybe it's my computer this time. But anyway, it's formula driven. It's the parent's income times the child support percentage is the dollar amount that you have to pay for the child. One child is 17%, 2 children is 25%, 3 children 29%, 4 is 31%, 5 or more is 35%. That's pretty much standard across the country. There may be a slight variation from state to state. Maybe you'll see 16% for one or 18%. It's the parent's income from all sources except for FICA, your Social Security taxes, which is about 7.25%, and any prior court order that you're paying for a prior child. That comes out of the calculation, and then what's left is your support. Now, obligation. Support cases are not heard by the family court judges, they're heard by support magistrates who really have very little discretion in changing the amount they start with that, and then you argue why you should not have to pay that amount. And usually it's because you're paying other things instead of that, that you're paying, let's say, private school tuition, or the child has a medical condition and you're paying certain medical bills, or have other extraordinary costs, or you're taking care of an invalid parent who lives with you. And again, parents can come to an agreement on support, either without going to court. If there's no order, parents can just agree, here's what we're going to do. And that's what they do. They don't need to go to court to get a support order. However, if they have an agreement, they can go to court, and if the court agrees, and again, the court will do that best interest of the child analysis, and may say, okay, even though it's not the guideline amount, the percentage amount, I'll order that. And one of the things I will say about child support right now, well, one last thing, and I'll get to that. Failure to pay child support, if it's willful, can lead to 6 months incarceration. And willful means you have the ability to pay, but choose not to pay. And if it's shown at a court hearing that you had the money, you just didn't pay, then you can do 6 months in jail for that. And among the cases I heard, in the 13 years I was on the bench, these to me were among the abuse and neglect category, that a parent would have the ability to pay child support and would just not pay, just decide not to pay. And they're already having an order saying that they're supposed to pay. It's like they're totally giving up on their child. Now, when I was talking a moment ago about modifying child support, if there's already an existing order, one of the three things is, one is after 3 years, one is if there's an extraordinary circumstance, and the third is if there was an increase or decrease of 15% in someone's income through no fault of their own. Well, what's happened in the last 6 weeks in this country and New York State and Erie County with the massive unemployment, people are going to be filing to have their child support changed until they get back on their feet. If you have a child support order that's currently out there and that you're paying or not paying, it continues to run and the arrears mount up. Even if you lost your job and you say, well, I haven't been working for the last month, you have to file a petition to modify. The timeline for the modification starts when you file the petition. So if you wait 4 months and now it builds up to thousands of dollars that you owe, and then you file the petition, it only counts from the day of the petition forward. The amount that got built up, the court has no jurisdiction over.
That was perfect. Someone had just asked that very question about changing the child support order due to loss of employment. So thank you for that.
I'll get to that momentarily, because the backlog in the courts right now, the courts are not open for regular business right now. And I'll get more into that later. Still file your petition, still do those things, but Erie County, the Zoom meeting I was just on, they have 2 months worth of petitions and mail that have been piling up because they've been shut out of the courthouse by the governor's order. Anyway, I will cover that in a few minutes. Paternity is also, we're talking about father's rights here. And really, father's rights is kind of a misnomer. as a judge, I would say it's children's rights, you know, and that's the way actually the case law is. The child has the right to enjoy time and the love and affection of both parents. It's the child's right to have visitation. It's the child's right to have access. It's not the father's right per se, although we think of it that way. It's really, just as we say, the bonding in the first 6 months and year is important. It's important for the child to have that relationship with both parents. And that's why joint custody is the preferred method, because it gives both parents the responsibilities and the enjoyment of being fully involved in the child's lives. However, paternity, fatherhood really starts everything. Without a determination of fatherhood or paternity, the court has no authority to make any decision about the child for anything, custody, visitation, or child support. Now, if a child is born during the marriage, the husband is presumed to be the father. That's a legal presumption, it's in the law. And the father's name is on the birth certificate. If there's no marriage, and the father's name can still be put on the birth certificate. If the father's name is not put on the birth certificate and you go to the family court, the first thing they're going to ask you for is a copy of the birth certificate. And you have to produce a copy of the birth certificate with your name on it. Otherwise, you file a petition for an acknowledgement of paternity, and then the court will determine paternity with an order of affiliation. Now, mom can come into court and say, yeah, Paul's the father, and agree and just have an order. But that has to be done before the court can get on to the next question of, custody or visitation or child support. Once paternity is established, then all the rights and responsibilities of parenthood follow: child support, custody, involvement in the child's life. If there's no agreement on paternity, if mom says, no, he's not the father, then the court can order a DNA test.
So what in the case of they're neither parent filing any kind of paperwork with the court? So in other words, no, there's no custody, no paternity established. You may have a birth certificate, but if there's no custody recognized by a court because of any petition, then is custody automatically assumed to be joint? How is that determined?
Yeah, I mean, the court only gets involved when people disagree. And,
Got it.
Most people live their lives without going to court. They can have disagreements, rough edges, get mostly muddle along life like most of us and get through every day. But joint custody, parents, even if they're not married, married or not married, figure it out. Mom takes the kid, makes the dentist appointments, tells dad when it is. If you want to come, you can come. Here's the, both parents know when teacher conference night is, those kinds of things.
So we have a question from Facebook, and actually it's a great point, a great place for me to say, please, for those who have been joining us and have been listening for a while, we encourage you to please respond, send us questions via comment on Facebook, and we will be selecting the next five folks, including this question that I'm about to read off. The next five folks who send in a question via Facebook will get a t-shirt from the Nurturing Fathers program. So Judge Buchanan, here's the Facebook question.
Yeah.
Does a portion of child support go back to social services? And I'm assuming they're inferring the Department of Social Services.
I know what that person's referring to.
Okay.
If I'll use the typical example, apologize if using stereotypical language, but let's say the mother has the child and the mother is on social services. and is on TANF or food stamps for the child. And the child is part of mom's family in the application to Erie County Social Services. In doing that, mom assigns her rights to Erie County to go after the father for child support. So mom gets her benefits every month from Erie County. Erie County then can file a petition against dad for what Erie County has paid for that child. Medical insurance. Now, even if it's not a whole lot, there it adds up. The state's Medicaid or medical insurance for children. So the county can go after the father and get an order to reimburse the county for the money that the county gave mom. If mom has an order of child support, no, that all goes to her. None of that goes to the county. And usually, and not usually, always, if you have an order of child support from Erie County Family Court, that family court, it'll go through the support collection unit in Erie County, which is tied in with that through the state system out of Albany, so that if you are in arrears on child support, it'll be flagged when you try to do your license again. If you have any tax refund coming from the federal government or the state government, it'll get siphoned off and given to pay your arrears, things of that nature.
Got it. So here's another question that just came from Facebook as well. And
Yep.
it is child support related. If I'm providing child support, it's a two-part question. How do I provide child support for my child without going through the court system? And I think I know the answer to that, but I'll let you field it. And then the second part of it is, if I'm providing support, then when and if I'm taken to court, does that count or does it not count? So the first part is how can I do it without court? And if I go to court and I've been doing it for a while, does it count or
So
not?
the first part is, again, most people, a lot of people don't go to court for support. They work it out themselves. Dad gives X amount of dollars a week, or he pays for this, she pays for that. People work it out like that. So you don't need an order. If you are paying voluntarily, it's always good to have a record. That may cause friction if you've not always been doing it by just giving cash. But keep a tally or send a check so that you have a record. But that's leading into the second question. Nothing matters before filing of a petition. So whether you've been paying or not paying, if there's no order and mom, in this case, assuming mom hasn't filed a petition, it doesn't count. But when she files a petition, that's the day the clock starts to tick. And support is calculated back to the day of filing. I think that answered the question.
Yes, thank you. And let me just tell our folks on Facebook, when you send in our questions and we answer them, please send us a quick email with your contact information to G Smallwood, GSMALLWOOD at sayyesbuffalo.org. And we will contact you about your gift prize. Thank you so much, Your Honor.
Yeah, and we got, since we're doing questions, I know there were a couple of questions that were submitted ahead of time. and I've covered some of those. One that I wanted to talk about because I'm not covering neglect and abuse or in this talk, and I'm not covering juvenile delinquency in this talk. However, the question we received was, can my child's mother terminate my parental rights? No. Answer, in 2 letters or less, no. Only a court can terminate parental rights. It takes years to terminate parental rights. It's only after a trial, and that the person whose parental rights, let's say in this case, the parent whose rights are being terminated, first has to be found neglectful, and that's usually after a trial. So that takes a long time, 1.5 to 2 years, because courts don't want to make that finding. Family court is about providing services. So if you have a person in a neglect situation, it means they already haven't participated or taken advantage of the county providing preventive services. And so if you have, they call child CPS on you, the first thing isn't that they throw the kid into foster care, unless the parent is unable to take care of the child at that moment. Like they're in jail, or they're in a hospital, or just gave birth to a child with drugs in the system, things like that. The first thing they do is they provide services, mental health services, counseling services, child care services, whatever it is, the preventive services to prevent the child from being taken out of the home. That's why it's called preventive services. After you either refuse preventive services or don't get better, so to speak, on the preventive services, then the county can file a neglect petition. And that's saying that you're not providing for the health education, you're not providing food, clothing, shelter for your child, or you're putting the child at safety at risk. And again, they continue to try to provide services, and that will take a long time. Those kind of cases are long. After you're found neglectful, then a whole new type of case starts. And that takes 1.5 years to terminate your parental rights. And we call that the nuclear option, because the family court's not in the business of terminating parental rights. Family court's in the business of trying to bring families together, give them the support to get through life. So if, going back to the question, can mother terminate my parental rights? No. And if you're not getting access to your child, file a petition for custody or visitation or whatever.
So here's a question related directly to that, because while the first one was about mom terminating dad's rights, this one is about one that I had shared with you also. What if a non-custodial father who has already been to court to try to establish joint custody, and that case is closed, and he's not allowed, he's trying to obtain joint custody of his daughter, his preteen daughter, where he and his wife are still married, but she is living, cohabitating with someone else. And there is ample evidence to suggest that there's some illicit activity going on, right? So this borders, previously you and I talked about this, this borders family court and criminal court, right? Because he is stuck in a situation where he wants to do the right thing and provide the appropriate security and shelter for his daughter, but at the same time, she's living with someone who could possibly inflict damage, harm to them, if he finds out that this is knowledge, this is something that he knows, and he's pursuing it. So we're just wondering.
Right. So the first thing is, if the parent believes that the child is at risk, has a safety risk, they should call the hotline, the child abuse hotline number that I gave earlier in the presentation in one of those earlier screens, when it had the screen that has Child and Family Services at the top. There are the 3 phone numbers: child abuse hotline, the addiction hotline, domestic violence hotline. They should call the 1-800 child abuse hotline. And if there is a safety risk to the child, CPS will be sent out within 24 hours. I wasn't sure if, from your question, that there was a prior order. If there is a prior order, they can, file for a modification if it's not old. And if as you pose the question, they're married, then he should divorce her. Well, that's a legal answer. I don't know if he wants to, emotionally or otherwise divorce her, but that, and any of those legal, many of those legal groups can assist him if he's unable to afford it, and file in Supreme Court. And in your divorce proceeding, you can ask for, as part of your relief, custody of the children. And one other thing is, if there is safety risk to children, you can file in court to get immediate relief. Again, under COVID, immediate, is not immediate anymore. The last general area of the law, and we've got about 15 minutes left, so I'm going to run through this and then how to access the court. Orders of protection. Family members are defined loosely in the Family Court Act, and it's any person who is a family member, whether they're living there or not, or anyone in the household, whether they're a family member or not. So if dad's girlfriend is beating on the kids, dad can get an order of protection for the kids, even though girlfriend is not a family member per se, what we would think of as a family member. There are 2 types of orders of protection. One is a complete stay away. That's a number 1, and that is what it sounds like. Can't go within 500 feet usually of them. No phone, no contact, any type, phone, Skype, no third party contact. Well, Paul can't talk to Fran, but he's going to have Joe harass Fran. None of that. Can't go to the place of employment, that kind of thing. Number 2 order of protection is no offensive conduct. This is not uncommon. It allows the parents or the people to be around each other, but they just can't engage in offensive conduct. No yelling and screaming, no fighting, no hitting, and especially all of this around the children. Orders of protection you can get without children involved. This is you have an adult child, taking advantage of a adult parent, a grandparent type of situation. So this applies, across the board. But in we're talking about children. This will allow visitation with no offensive conduct. Dad can have visitation. He just can't have, he can't be yelling, screaming. They may say girlfriend cannot be there if she's the problem. It may be dad can have visitation in a public place like a park or things of that nature. So the things have changed, dramatically for everybody and everything over the last 2 months. When I was going to do this presentation, originally it was going to be March 28th at the Harvey Austin School, as I said, in person. Now things have changed. Things are changing every day. I just had information before beginning this presentation about changes that are happening in the courts today. Erie County is beginning to open their courts this week. They were just told Monday that they are now in the governor's phase 1. Ironically, lawyers' offices are considered services. They're in phase 2 of the reopening. So they don't open for a couple more weeks, maybe. So there's kind of a disconnect there. It's going to be a slow process. Everything that I told you now, leading up to now about your rights and everything, if you have to go to a court to enforce them, you should still do that. And I'll tell you how to do that momentarily. But what had been slow in the past is going to be very slow, for months. And there's nothing people can do about it. It's social distancing. If anyone has been in family court, they know it's not conducive to social distancing. Conference rooms are small and cramped, and with 4 chairs in them, and you close the door. Well, that's not what you're supposed to do. The waiting room, the waiting area, it's like being in a packed movie theater. Well, I just found out that there are 28,000 petitions from the last 2 months that have not been processed because the court has not been able to process it. And that's the volume that goes through family court each and every month. So anyway, you can still have your cases heard. You need to, fill out those petitions. But how to deal with the other person in this period of COVID-19. Let's try to work with the other parent to find a creative solution, even while you're waiting for court. Zoom, like we have here, Skype, Marco Polo, phone calls, FaceTime, whatever. You can ask for makeup time if the kid's missed. Whatever you do, make a record. Document all of what you're doing, all of your communications with text or email. Don't, even though you may get frustrated, don't put that frustration into an email or a text, because as we all know, anything that goes onto the internet or a text is out there forever. And if you blow off steam at the other parent and put that in the text, the other parent's going to say, see, he's yelling at me. That's why I'm afraid of him. Seek help from others to intercede, either go to mediation, as I put forward earlier, clergy or family member or friends. If you have to go to family court, I would suggest try contacting one of those legal resources earlier on to see if they can assist you. Go to nycourts.gov to get the form that you need, and I'll show you that in a moment. On that New York Courts website, the first page, the upper left-hand corner will be home. The first page is now a new notice having to do with COVID. Look at that, go up to the top left, click home, and there are a lot of DIY, do-it-yourself help information. If you must, and send the petition, either mail it or email it, and there's a way to email it that I'll get to in a moment. If there's an existing order out there already, you must obey the existing order. No self-help, because courts don't like it when if you self-help, then the other person will self-help, and it will spin out of control. So if you go to newyorkcourts.gov, we are all now using virtual courtrooms, even though the courts opened up sort of this week. And I say sort of because not all the courtrooms are open. The support magistrates are not coming in until next week. And because of social distancing, not all of them are coming in at the same time. This is a statewide directive from the courts. It's not Erie counties say, it's not the 8th Department, Western New York say, this is coming, statewide. If you, everything is being done by virtual courtroom. If you do get into a courtroom yourself, chances are you won't be seeing a judge sitting up on the bench. The judge may be on the monitor. And again, social distancing, this is going to be the new normal for months and months and months. And we don't know, if things are going to be shut down again. If that second wave hits that, people have been talking is a possibility. But in any event, don't let that deter you from filing a petition, because nothing starts until you file a petition. I'm just warning you of the situation that the courts are in. So if you go to that newyorkcourts.gov website, the first page, in the middle of the first page, you will see highlighted EDDS. That stands for Electronic Document Delivery System. You will want to use that if you want to email your petition to court. And it has, click on that and it gives you a step-by-step how to use it. It's essentially a form that you fill out that has your name, address, contact information, what the case is about. And it's just a one-page form that you fill out that you would send, and you attach your petition to it. Now, to get the petition on that page, go to the top left, click home. The next screen comes up, and on the left, under courts, on the left side is courts at the top. Click down to forms. Click on forms. The next screen comes up, and there's a list of topic areas alphabetically. Click on family or domestic violence if you're looking for that. But I'll say family here. Then the next screen brings you to the forms that you need. And then they're listed by topic area: custody and visitation, child support. And those will be, if you want to have a violation, as I said, whether a new petition, a violation, or a modification. That whole list of forms will be a new petition, violation of a visitation, violation of support, modification of support, modification of custody. So there'll be a whole list there. Click on the one that you need. I would, of the forms list on the right has 3 categories that you can click on. The first 2 are the best. The first one is a PDF, and it allows you to just print out the form. You fill it in by hand and you mail it to that address I gave you on one of the first slides, the address of the Erie County Family Court, 1 Niagara Plaza, 14202. If that's all you do, it gets in there. If you want to email it, then use the middle one, which is a Word document. You pull that up and you can fill in everything rather than writing it by hand. It's the same document, same form. You type in Paul Buchanan, here's my address. You fill out the form, fill out what you're asking for. If you had to add more, if the spaces aren't big enough for your complaint or the situation, add another page. More is better. If it's not in your petition, that doesn't exist. You can't go into court later and say, oh yeah, I forgot to say this, that, and the other thing. Well, this, that, and the other thing doesn't count if it's not within the four corners of your petition. So take the time to put everything into that petition. If you're using the Word document or either of them, if you fill out the document and you scan it back into your computer, or if you download it after filling out the Word, then you go back to that first screen, the EDDS, the document delivery system, and then use that to email that form to court. Or, as I say, you can either email it or just put it in an envelope and mail it to this address. And also, as I said before, any of those other organizations would be willing to take your phone call if you need more help. And I think that's about it. We may have a minute or two left. I think that's the end of my presentation.
Let me just say, Judge, as you were calling out those instructions,
Yeah.
I minimized my screen for a second and went to the newyorkcourts.gov website and did exactly what you said. It was so easy. It's just click of a button from home to the topic to the specific paperwork. And it starts to look daunting, but it's very, very, very simple to access. But for anyone who's still joining us, still with us, or just joining us now, if you need this kind of information or assistance for any civic legal matter, please, on screen now is the Volunteer Lawyers Project, and their job is to assist you in these legal matters, right? They can answer all your questions. Also, I just wanted to say we did have a few folks who submitted some questions, which Judge Buchanan so aptly answered for us. Jason Prophet and Celicia Thais, we're going to be contacting them because they did take the opportunity to send in some questions that really added to the conversation. And I just want to say, I feel like we're going to need another part to this, Your Honor. What do you think? I mean,
it never ends, obviously. And even saying the same thing to a different group of people another time, it gets the word out. And, with the COVID pandemic situation, that's changing all the time, and as I said before, the supervising judge was just saying today on the Zoom meeting that, no one knows when the courts are going to be back to normal, and no one knows what the new normal is going to be, but no one expects it to be the way it was March 13th when they closed. And talked to a couple of judges, they said they were told that Friday, take what you need because the building's going to be closed. And, they didn't know for how long. So they gathered up their stuff and they thought, well, we'll be out for a couple of days or maybe a week or so. They never imagined they would close for 2 months.
Yeah, talking about 28,000 unanswered petitions later, which is the result of 65, 66, or 67 days in COVID.
Yeah,
that's a lot of petitions to wade through. Your Honor, I have one final question here.
Yeah, go for it.
It came up from Terry C. So this is a child support question, but from a different perspective. So he's raising, there's a child in the household, and so there should be child support coming into mom for that child, but there isn't. And so a petition was filed. They went back to court, and it seems that this happens with a fair amount of regularity. It seems it's every 3 months. So 9 months later, here they are doing the same thing, the same thing. So I'm just wondering what your thoughts are. Do they continue to file just a regular petition for modification, or I think at this point, this is a violation, right?
Well, yeah, and a violation and enforcement, and they should have at the end, if you file a violation and ask for enforcement, then you'll be able to get a judgment against the person for unpaid child support. Now you can file that judgment against them for what it's worth. Sometimes it's worth something. You'll find out that maybe they have property that they're not disclosing. I had a case where I was representing a client some years ago in the child support, and the guy was saying, "Oh, I have no money, all this," and I did a property search, and I realized he was a slumlord, not a slumlord, but he owned property. And I drove around, and I looked at the property, and he was renting it, and he didn't have mortgages, so they didn't show up in any bank statements, but showed up in the property rolls. I was able to get a judgment for owed child support and then file that judgment against his properties. And he had, and then there's other procedures to try to get the money. You can actually force a foreclosure of the property for your child support. That's extreme, but that's what it would take.
Gotcha. Well, here in our closing minutes, I just want to say, first of all, thank you so much, Judge Paul Buchanan, for your wealth of wisdom and experience, everything you've done for our Buffalo community here, and especially for taking the time to answer these questions. Just to let everyone know, our winners for our raffle were Terry, Justin, Daytwan, Rodney, Keith, all these folks. Please email gsmallwood@sayyesbuffalo.org to claim your prize. And also know that we have recorded this, and so we will take every opportunity to send folks a PowerPoint, a copy of the PowerPoint, as Judge Buchanan pointed out earlier. This is free for everyone, so we do want to provide that information as a resource. And you can watch this again later on various channels. I see Reggie Cox, one of our trainers. How you doing, Reggie? We've got Buffalo Public Community Schools on Facebook, Parent Center, and you'd be able to see those there as well. So if you want to see this video and get some of the information again, you can see it, hear it, and we can send you the PowerPoint. All in all, I'm told we had some 607 viewers. So Judge, just know that where we had initially planned for a small, 50 plus perhaps gathering, COVID did us a favor because you were able to reach over 600 people. So before we get signed off here, just want to say thank you everyone for logging in, and thank you again, Say Yes Buffalo, Buffalo Prenatal Perinatal Network, Community Schools, Parent Center, Buffalo Public Schools, and last but not least, Volunteer Lawyers Project and Judge Buchanan. Thank you so much for joining us. Hope to see you again on our next installment.